Welcome to the Business Compass bite-sized webinars. So these webinars are focused on delivering complex legal topics in bite-sized chunks for everyone to be able to digest those. My name is Richard Coulthard, and I'm a director at Ice and Harrison Solicitors. I head up the commercial teams, and today we're going to be talking about directors' duties and avoiding conflict. We quite often find when advising business owners that they don't always fully understand their obligations as directors, and this becomes particularly relevant where directors have a falling out. And we're going to look at some of the issues that arise, how you can avoid complexities, how you can avoid disputes where possible between directors, and give a basic explanation as to some of the duties that directors have when running a limited company, some of which may not be known. And it's one of those interesting topics, I suppose, because you don't get any formal training about how to be a director and what your obligations are. And therefore, some people do fall foul of some of the statutory obligations, and these can have far-reaching personal consequences, including in serious cases, disqualification as being a director and personal financial liabilities. So, first thing to understand, which in sort of SME world, a lot of people don't necessarily appreciate, is the difference between a director and a shareholder. Now, for most SMEs, they are one and the same. The directors also own the business, but legally they are actually two distinct roles. The shareholder owns the business. The director runs the business for the benefit of the shareholders. Now, for a PLC, BT or British Gas or whoever, it's quite a clear distinction. You've got directors who run the business and they run it for the benefit of the shareholders. But in the SME market and owner-managed businesses, they tend to be one and the same in most situations. And people don't necessarily understand that there is a difference between your rights and obligations. Directors have certain statutory responsibilities and common law responsibilities in terms of how the business is run. Shareholders don't tend to have much in the way of statutory obligations, and actually their right to information is fairly limited. They do have rights to request certain information about the company and things like that, but your rights and obligations as a shareholder tend to be much more limited. The reason I mention this is we do see disputes between, broadly speaking, shareholders within companies. And a shareholder who's not a director probably has less in the way of obligations and rights than a shareholder who is also a director. So it's important to understand this difference. And we're going to come on to some of the issues that arise as a consequence. Now, firstly, directors' duties under the Companies Act. Now, the Companies Act, it governs all company law, and it sets out the legal obligations of directors in statute. And I've put them on screen. I'm not going to go run through all of those. I'm going to come on to some of them in a bit more detail in a moment. If you did want to read the Act, these are the sections that they cover. It's a designated section of the Companies Act. But broadly speaking, the obligation of the director is to run the business independently for the best interests of the business and ultimately the shareholders, and to avoid conflicts of interest. And this is where some directors can fall foul, is they don't necessarily distinguish between their obligations as a director and the interests of the business, which is technically a separate legal entity. So, for example, if you're going to be entering into a contract with maybe a relation or a family member or something like that, we need to be careful to avoid conflicts of interest and actually who's the contract is for the benefit for example. So, dealing specifically with the duty to promote the success of the business, which is under Section 172 of the Companies Act. The overriding obligation of the director is to do the best to promote the success of the business. So that is, you need to help try and grow the business. You've got to make decisions that are for the best interests of the business and not for the directors as individuals. And when it comes to disputes between directors and business owners, this is probably one of the key provisions that can be relied on, where we find situations fairly typical. You've got a handful of directors, and one of them feels like they may be getting ostracized or might not be engaging with the business, and they don't want to take certain steps. So, for example, we've had one recently we advised on property business. 3 or 4 directors, they've got land in the business and they need to refinance one of those properties. And one of the directors, because he's somewhat ostracized from the other directors, is refusing to sign the mortgage documents. And this person is doing so purely from a personal standpoint of I'm not getting on with my other shareholders, my other directors. But it actually would be in breach of the of Section 172 of the Companies Act, because he's not acting in the best interest of the business. So this is one of the key elements of the statutory duties where people can rely on, that there's this underlying obligation to act in the best interest of the business, not engage in contracts or obligations which are detrimental, or for which it's a conflict of interest. So you can see on screen there some of the specific obligations. By and large, they're fairly common sense, actually. Are you doing whatever action you need to do, which is going to ultimately promote the success and the growth of the business? The next one I just wanted to focus on is Section 174, which is the duty to exercise reasonable care and skill. Now, this sits quite closely in some ways with the duty to promote the success of the business, but dealing specifically with situations where there may be conflicts of interest. Is the director acting independently, using the general knowledge, skill, and experience that might reasonably be expected of a company director? So these are 2 key statutory obligations where people can rely on other directors, shareholders, things like that. Potentially, in some situation, customers or third parties, where directors haven't acted with reasonable care and skill. And in certain situations where directors breach their obligations under the Companies Act, it can mean either that their actions are unlawful and then it might not bind the company, or that there could be personal liability on the director for acting in breach of the Act. The next element that I wanted to cover is under the Insolvency Act 1986. Again, this is an area that a lot of business owners don't necessarily understand, because the hope, of course, is that businesses are going to trade successfully and are not going to need to be closed down, whether that's a solvent liquidation or an insolvent liquidation. But sections 212 to 217 of the Insolvency Act can place personal liability, including financial liabilities, on directors who are acting in breach of the company of the Insolvency Act, I should say. And a couple I want to focus on specifically is Section 213 and Section 214, which is wrongful trading and fraudulent trading. Now, these have quite serious ramifications, not just financially, whereby the directors can have personal liability to pay the debts of the company, but also can result in directors being disqualified from being able to run other businesses in future. Now, this obviously has far-reaching consequences. There are many directors who run multiple businesses, and it may well be that their actions or inactions in one particular business could impact their livelihood elsewhere. So, fraudulent trading, Section 213. This is the more serious offence, in which a director of a business knowingly and fraudulently continues with the business activities of the company, knowing that this is intended to defraud the creditors of the company. And we go back a few years and you potentially look at the likes of some of the COVID bounce back loans, coronavirus business interruption loans, things like that, where people took out credit with no or little intention to repay that, have used that money for purposes other than for the business, potentially purchasing vehicles and things like that. Um, some of these scenarios are now giving rise to serious repercussions, both in terms of insolvency and also with respect of HMRC. Fraudulent trading does involve some sort of intention, some sort of deliberate act to defraud the business. So what I'm saying is, in the vast majority of situations, directors will have gone into this knowing that they are doing something wrong. It is unlikely to be something that a director can commit unwittingly. Section 214, however, is wrongful trading, and again, this is where directors can fall into something of a trap because they may not be aware that what they're doing is wrong. Now, where wrongful trading comes in is where the directors know or ought to have known that a business was insolvent and have continued trading in any event. And this is something of a subjective test in terms of whether they knew or ought to have known that the business was insolvent. And an insolvency practitioner will look at the individual circumstances to see whether that is wrongful trading. When a director knows that a business is insolvent, or ought to know that a business is insolvent, the obligation of the director switches so as to protect the position of the creditors. And if they fail to do so, then the directors can be personally liable for all increased costs and credits, which then becomes owing to the creditors. So an example of this would be a business that has been struggling for trading, for example, might have goods that are being purchased on credit, so they're not paid for upfront. And they might be on 60, 90-day payment terms, and the director thinks, well, actually, if I can just get these goods in, I can sell the goods, and then I can pay off my creditors. Well, actually, that might result in a director being unwittingly guilty of wrongful trading under Section 214 because they've obtained the goods on credit knowing, or they ought to have known, that there's a realistic risk that the creditor, i.e. the manufacturer or whoever who provided the goods, may not get paid. It's a fairly complex provision, but we'd have seen situations where directors are potentially guilty of wrongful trading, having not done anything deliberately wrong, but they have taken action which they should have taken independent advice on. Best advice for a director is, if you've got a business that is trading poorly and you've got questions about the solvency of the business, that you should speak to an insolvency practitioner or your accountant to get expert advice and then follow that advice. If you take advice and then don't follow it, there's a very good chance that you're going to be in breach of the Insolvency Act if the business subsequently becomes insolvent. Now I'm going to touch upon the Articles of Association. So the Articles of Association is essentially the company's rule book. And frankly, in many situations, in many SMEs, it's something that is largely forgotten. Certainly, if you've got a business that was created after 2006, that's adopted model articles, they're fairly loose as to the obligations. If your business was incorporated pre-2006 and it's got old, what we call Table A articles, the provisions are a little bit more extensive. I say that this is forgotten because many directors feel that they can make whatever decisions that they want. They're the directors of the business and it doesn't matter. Technically, directors have to act in accordance with the Articles of Association, which is the company rule book. And this might have obligations, including declaring conflicts of interest that a director might have, how those conflicts are resolved, the minimum number of directors that have to be at a meeting before a decision can be made, and various other obligations. And if a decision is made by the directors of the company, which is contrary to the Articles of Association, it may result in that decision being unlawful and they've been challenged and potentially are being overturned as being something that the company wasn't actually allowed to do. We would always recommend that you keep your articles up to date and that actually you understand what the obligations are in them, and that actually if you do have some unusual decision-making obligations, or you've got different share classes, things like that, that you keep your articles up to date as to what the decision-making process actually looks like and is appropriate for your company. Because it isn't referred to day in, day out by a lot of directors, like I said, it quite often gets forgotten about until there may be a dispute, in which case lawyers such as ourselves potentially then pore over the Articles of Association and go back on certain decisions when we may go, there's certain decisions that have been made unlawfully and then look to unwind them. So there can be complications from not following the Articles of Association. So dealing now with direct disputes, and again, we do a lot of advice on this type of issue, and the scenarios we quite often see is a business that's got 2, 3, 4 directors, and it could be that they are 50-50 and they're not getting along. It could be some family ties. It can be a range of situations. But a common theme often is that they have very little in the way of formal documentation. They may not have a shareholders agreement, they may not have employment contracts, and this is particularly problematic where you've got 50-50 shareholders, is understanding actually what steps can directors lawfully take if they've got someone in the business, another director who's either not pulling their weight or maybe something of a rogue director and actually almost acting in direct contravention of their obligations. Well, I've already mentioned it's key to understand what's the difference between being a shareholder and being a director. Director will probably have more obligations and a greater degree of power than just someone who owns shares. The next point to consider, however, is the employment position. Is the director employed? Shareholders unlikely to be employed. It may be employed, but actually you've got a whole piece around employment law that you need to think in terms of, do you have to go through a disciplinary process and dismissal and run the risk of employment tribunal proceedings and all the rest of it. It may well be that their employment terminates and therefore in some circumstances their directorship terminates, but they still own shares. The two need to be distinguished. The general position is that you're going to have to follow the same sort of employment process, a disciplinary process or what have you, as you would do with any other employee. But it's important that you follow that process, because if you don't, then you may end up with employment tribunal proceedings being pursued against you, irrespective of any shareholding or otherwise. I'm going to mention unfair prejudice. So this is a minority shareholder protection. So if you've got someone who owns less than 50% as a minority shareholder of the shares, and decisions are being made in a business which is to the detriment of a minority shareholder, the minority shareholder may be able to bring court proceedings under Section 994 of the Companies Act, so as to normally the outcome is to force the other shareholders or the company to buy back the shares of the minority shareholders. So an example of this, for example, would be a majority of shareholders deciding to only declare dividends against their own class of shares and not against that of a minority shareholder. This could be an example, that isn't always an example, of a situation which may give rise to unfair prejudice. Or something else might be changing the rights attached to certain minority shares, removing voting rights, or something else that's going to negatively impact the position of a minority shareholder. Now, it may well be in certain circumstances that the majority shareholders almost wants to force a position of an unfair prejudice claim as a mechanism to get back the shares. Such approach is a possibility, but should be approached with caution because there are potentially cost consequences and things like that. In most situations where there's a dispute between directors, the resolution is going to be either for one shareholder or one group of shareholders to buy out the other, in which case you probably need a company valuation and to try and come to an agreement as to what the figures look like, or to wind up the business. So we close the business down, everyone takes their own amounts that they're due through a solvent liquidation, or the sale of a business to a third party. But the right outcome is going to be dependent on the individual circumstances. Expert advice should be taken from a lawyer fairly early on if there's a likelihood of a dispute arising. So as also protect the business. What we've certainly seen in our experience of advising people in this situation is where there is a fallout between directors, it inevitably negatively impacts the business. The value of the business potentially decreases, the trading of the business decreases, and that ultimately costs everybody. Because if the trading of the history of the business decreases, it becomes less profitable, what have you. That's going to affect the value of all of the shareholders. So these issues need to be ironed out fairly early on. And litigation, whilst it may be necessary, should be avoided because litigation can become costly. So our advice normally is to try and seek a resolution fairly early on, but with the fallback position that actually if there is someone who's been difficult or what have you, that various forms of litigation may exist in terms of breach of employment contract, shareholders agreements, breach of the Companies Act, unfair prejudice, winding the business up on just electoral grounds. There's a range of options there, but take advice early. Something to mention briefly about deadlock, that is particularly problematic where you've got shareholders who have exactly 50-50 because most decisions in the business require what we call an ordinary resolution, i.e. over 50% of the shares. Now, if you've got a dead 50-50 split, neither person has a majority, and that can give rise to a complication on this. Be mindful. We see situations where business owners receive advice normally from their accountants to split shares with spouses and family members for the purpose of saving tax on things like dividends and things like that. Just need to be a little mindful about the risk of this deadlock situation or what happens if the relationship breaks down, because again, we've seen lots of issues around that. There may be alternatives to doing a full 50-50 split to achieve a similar outcome, but again, expert advice should be taken. And finally, some top tips as to what you can put in place so as to avoid these situations of arising. We'd always recommend a shareholders agreement for any business where there are multiple shareholders. I've heard stats of something like 70% of SME businesses don't have shareholders agreement, and it's one of those documents that frankly you hope you never have to rely on, but is comparatively inexpensive to put in place compared with the position of what happens if you don't have one and the parties fall out and you start talking about a litigious approach. So have a shareholders agreement in place. Director service agreement, so that's essentially a form of an employment contract, but it deals with things like statutory duties and what have you, so get those put in place. Bespoke articles of association, make sure your company rule book is actually fit for purpose, fit for what you want to have in your business. Another one to think about, which I've mentioned at the bottom of the slide, is a cross-option agreement. This covers a situation in the event that a shareholder is to pass away and how those shares are then bought back either by the company or by the remaining shareholders rather than passing into the estate of the deceased. Quick point on that, we do see other law firms drafting a mandatory obligation to transfer shares on death in either the Articles of Association or the shareholders agreement. I would caution against this because it probably disqualifies the estate from getting what we call business property relief. So you could end up paying more tax. So just something to be mindful of there. Always be mindful of what happens in the event of a deadlock, i.e. shareholders can't make a decision. If shareholders are 50-50, we can include provisions in the shareholders agreement that deals with that situation. And finally, as I've already mentioned, if you've got spouse or children or what have you with shares in the business, or you're advised to give them shares in the business, just be mindful about the risks that may be involved in this event of some sort of family fallout, some sort of divorce proceedings, things like that. Again, we've seen complications arise where there are husband and wife or what have you who own a business together and they're getting divorced, they fall out, how practically that business can then run, and certain shareholders potentially being a little bit difficult about things like access to the bank account and things like that, it can have a really detrimental effect on the business, and we just need to be mindful as to how we manage that risk insofar as possible. So, top tip overall is make sure you get the right framework for your business in place at the outset or as early on as possible, because in the long run it will certainly save you money rather than going through a contentious process in the event of a fallout later on. So that concludes the webinar today. Hopefully that's given you some top tips and a bit of information about your obligations as a director and what to do if you're aware of directors or shareholders who are falling out. Of course, if you want further advice or have got specific questions about individual circumstances, please feel free to contact me on the details on screen. As I said, we advise a number of business owners on issues such as this who've got a lot of experience, and the advice really has to be tailored to the individual circumstances of the parties concerned. But we'd be more than happy to have no obligation initial consultation to talk you through and answer any questions that you may have about your particular circumstances. Thank you for joining us today. This has been the Business Compass bite-sized webinars brought to you by Ice and Harrison Solicitors, and I look forward to seeing you next time. Thank you.